Welcome back, everyone. This is Austin right here at 2FBC Tactical. Going to give you kind of my thoughts on what just happened at the Supreme Court this week. Now we're talking about the Hemani case. So let's dive right in. All right, guys, this is challenging United States 18 U.S.C. Code 922G. Paragraph 3, specifically on the subject of marijuana. That is what this particular court case is on. And it's rather interesting, and I have some thoughts on this, and I do want to give a huge shout out to Mark Smith with the Four Boxes Diner. He is someone that I do rely on heavily for stuff like this. You guys should go check out his channel, absolutely, if you want some in-depth dives into Supreme Court thinking and how these cases get bantered about. He is definitely someone to go listen to. And if you don't mind, like, commenting, and subscribing, we appreciate all of you. This channel is growing rapidly, and we really do appreciate that. Can't wait to bring you more content. We've got a bunch of stuff coming up, and we're making that push. Go over the Rumble. Make sure you hit a thumbs up over there. All this stuff is always linked up in the description down below, including the case that we're talking about today. So when we dive into this, we're talking about oral arguments in the United States versus Hemani case. Now, first off, it should be mentioned that this is a horrible case when it comes to the facts for the Second Amendment to be brought up before the United States Supreme Court. The Trump administration, who made this decision is up for debate. Mark Smith, for instance, is not of the opinion that Pam Bondi had anything to do with this. If she did, it was a poorly chosen case. He seems to lean more into the likelihood this was to rack up wins for the Solicitor General's office as opposed to making an actual argument on the facts. If that is the case, shame on anybody who did that, because the reality is that the government's job is to protect the rights of you and I. That is their job. Their job is to ensure that the Constitution is followed to its fullest intent, and that the individual liberties of the citizens underneath it are not being infringed upon, whether that be a state, the federal government itself, or anything of the sort. So Hemani is a bad guy, okay? Let's just say the obvious. The plaintiff here is not a good individual. He is someone who has touched base with the Iranian Revolutionary Guard, which is a designated terrorist organization, and has a string of legal issues of himself, outside of this, I should say, for himself. But what this particular case is dealing with is the firearm charge that he got hit with because he uses marijuana. And under 18 U.S.C. 922G, it does allow the prohibition of firearms towards anyone that is an unlawful user of drugs. So when you fill out your 4473, you're filling out questions there at the bottom, and then you're going to sign and date towards the end. That whole question section is filled with prohibiting people. That's what the whole point of that questionnaire is. If you answer one of those wrong, we as the dealer cannot sell to you. Quick pause in the video, guys, to give a shout out to our channel sponsor, Patriot Mobile. Now, I've personally been a member of Patriot Mobile for several years now. Everyone is using a cell phone these days. So the question is, why not support someone who supports you, who stands up for the rights that you and I hold dear? And Patriot Mobile puts their money where their mouth is by donating a portion of every dollar they make to the causes that you and I hold dear. They use the same 5G networks that every other major provider uses. You're not sacrificing service. You're supporting a company that will support you. They're going to give our listeners a special discount. Using the code SHALLNOT and clicking the link down below, you will get a free month when you switch to Patriot Mobile. With that, let's get back to the video. And there is a question on there that says unlawful users of drugs, which marijuana is in big bold letters underneath there, falls underneath that regardless of state law. This is where the issue, though, does lie when it comes to this case, is because marijuana is legal in 31 or 32 states or something like that now, at least in minimal for medicinal use, if not for more. And the the federal government doesn't even really pursue marijuana charges much anymore, unless it pertains to firearms, because the government is always looking for a way to deny the rights to me and you. So therefore, they'll use whatever they have on the table. And the issues here, too, is the unlawful user standard that the government is attempting to put forth is extremely vague and is left up to the NIH and stuff to make these designations, and it's very, very vague. This is something that several justices, including Ketanji Brown Jackson, for instance, actually had some issues with the government on. Neil Gorsuch was the most pointed of this. He hammered the Solicitor General attorney, I think it was Sarah Harris, if I remember correctly, on this issue. First off, he was like, why did you even bring this case to us? This is not a good case on the prohibited persons question when it comes to the Second Amendment. The founding fathers could be disarmed, is what Neil Gorsuch said. In fact, let's listen in on that part.
Just want to, before we lose track of what Justice Sotomayor is talking about, one can ask whether the habitual drunkard statutes are sufficiently, the how and why is sufficiently analogous. Habitual drunkard, the American Temperance Society back in the day said 8 shots of whiskey a day only made you an occasional drunkard. We have to remember the founding era if you want to invoke the founding era. To be a habitual drunkard, you had to do double that, okay? John Adams took a tankard of hard cider with his breakfast every day. James Madison reportedly drank a pint of whiskey every day. Thomas Jefferson said he wasn't much of a user of alcohol. He only had 3 or 4 glasses of wine a night. Are they all habitual drunkards who would be properly disarmed for life under your theory?
No, and again, I think this is something...
Okay, if they're not, then what do we know about Mr. Hemani? We know he uses marijuana a few times, about every other day. That's all we have in the record, right?
That's all we have, and I'm
Okay,
not troubled by that.
so we don't even know the quantity of how much he uses every other day. What if he took 1 gummy bear with a medical prescription in Colorado? Well, you may not even need a medical prescription. You don't even need that anymore. But let's say he had one to help him sleep every other day. Disarm him for life?
Well, no, it's not disarm for life, and here's what's going
Potentially.
on.
Would that be enough under your theory? 1 gummy bear every other night with a medical prescription.
So I think you'd have a potential rehafe problem, but I will accept the hypothetical. So let me just deal with
I think
what's
the
an
answer is
unlawful
yes,
user.
under the government's theory.
Yes, under our theory, but let me give you an explanation of 2 parts of this that are important. One, you asked about how do you tell who's an unlawful user? How is it more defined than a habitual drunkard? I think it's a lot clearer.
Is it? I mean,
yes.
the government has not been able to define what a user is. I mean, it is said at various points that it's someone who's used any illegal drug in the past year, right? It said, ATF now wants to say a pattern, and you argue for habitual, which of course conflates the second half of the statute, which talks about an addict, which is different than a user, and an addict is an habitual user, it's defined as. So you're kind of conflating the 2 parts of the statute there. So tell me how it's so clear.
Okay, a couple of things to help you with this. One, I'm going to set aside the forfeiture issue, but I would like to return to that later. Just deal with the substance. With respect to who is an unlawful user, the Court of Appeals are uniform in adopting the same view as us, which is it is a habitual user in context.
But the ATF disagrees.
No,
apparently.
they absolutely do not.
They say a pattern.
Let me be very clear about the distinction here. There is a distinction between what is the statutory definition of an unlawful user, and everyone has always agreed, including ATF, that that means habitual or frequent. And on the other hand, how do you prove that? What type of evidence is sufficient to show beyond a reasonable doubt, or for purposes of background checks for ATF purposes, that you in fact do that? So
okay,
that
so
is the discrepancy.
circles us back down to you would qualify as an habitual user, 1 gummy bear every other night.
Absolutely, and here's why. The check on that sort of situation is twofold. One is you have to know that you are using an unlawful drug. So if you're using your gummy and you don't know that it has THC in it or there's something else, you could have a nice rehafe defense. But setting that aside in terms of other guardrails, illegal drugs are different from habitual drunkards in an important way. First of all, there is robust post-ratification history that I think shows that there is a tight connection between someone who is a
So if it
habitual
all
drunkard.
boils down to illegality, what do we do with the fact that marijuana is sort of illegal and sort of isn't, and that the federal government itself is conflicted on this? It doesn't enforce it quite the same way it does with respect to drug laws with respect to other drugs.
So 2 points. One, it's not just illegality, but with respect to illegality, I don't think the government is of two minds. The government is considering rescheduling marijuana as Schedule III to facilitate potential medical applications, but the government is not saying that it is not illegal anymore simply because states are not following federal law. I think the fact that the Controlled Substances Act is involved, it brings this not just in terms of the category of illegality, but into the realm of how do you test the fit? How do you test if Congress is like prohibiting chewing gum or caffeine on the one hand, legal substances, versus substances that actually do have intoxicating, mind-altering effects.
Okay, but
So as you can see, there was a lot of questions on the government's stance. So I will say this: there's a possibility in this case, and again, I'm not a lawyer. This isn't a legal advice breakdown. It's just more of what the courts or the questions that were asked by the justices and where it more than likely is going to fall. Justice Alito and Roberts, they're going to go for the government here. Reason why is they are not a fan of drugs. They are very harsh on drugs. They have always been throughout their judicial career. And I suspect that because this guy was a drug user, they will continue to be so here. So you're going to lose those 2 votes in the normal pro 2A side. What was interesting is Justice Jackson. She is not the best justice we've ever had. I had to say it mildly. In fact, I would make the argument she is one of the worst that we've had. Listening to some of her questions and the depositing she has done from the bench thus far in her young career, it's very much an activist judge for sure. She had some questions on this under the Bruin standard, which she was holding. And I think if we should take anything away from the oral arguments here is that the Bruin standard of text, history, and tradition rules. And it still rules, and the court is holding that. They are not wavering from that. Because even she kind of utilized that thinking when it came to the Second Amendment in this case. And Justice Barrett had questions to the government as well about the limiting factors being so vague. How could one know whether or not they were an unlawful user or not, and honestly answer that question, especially with the government now working to reclassify marijuana. That is something that the Trump administration is currently signed an executive order on, and they're working towards. So personally, I think it could very well be a 5-4 decision in our favor, which means this would backfire heavily on whoever chose this case. This case was not brought to answer the unlawful users question, at least not in our favor, I should say. This case was brought to take an unlawful user that was in this person's mind, whoever chose it, slam the door on anyone challenging an unlawful user. And there's clearly some heavy questions, at least from the justices currently on the bench in that department. I could see this backfiring on whoever chose this case. And I think it might happen that way, where we get it will be a narrow ruling, and it probably will be on the marijuana only part of the question. It won't be necessarily on various other illicit substances, say like cocaine, heroin, anything like that. I could see it being very narrowly tailored to marijuana itself, but more than likely, I won't say more than likely, I think it leans probably 60-40 in our favor based on the arguments. I think we might get a 5-4 decision in our favor on this one this summer, where they will say that this part of the conviction should be overturned. They could even tailor it just to Mr. Hemani himself and make it extremely narrow. If there's anything good that come out of this particular case, despite the fact it's not a great case for us, I should say there's 2 things I think we can take it out of this case. I think the courts are very open. The Supreme Court is very open to the prohibited person question. If we bring them a great case with good facts, meaning the person was a choir boy basically, and you slapped him because of something uber minor, they probably will come out and slap a lot of that down. They really gave some heavy indications that they're open to that. The other thing that I think that is good here is they are not going to do a broad ruling, more than likely one way or the other. So we're not going to see like the rolling back of the Bruin standard or anything like that out of this case. This is going to be very tailored to these set of facts and probably this individual. If not this individual specifically, I would imagine the marijuana question on the prohibited persons list, it might be removed. I don't think this is going to be broad one way or the other. Now, that's a shorter video today. Please like, comment, subscribe. Make sure you go over to our Rumble channel and give a thumbs up there. I did write about this. This is on our news section, so go check it out. We're always writing and updating on this and all the other cases going on throughout the United States, whether it be here in Minnesota or, even in other countries. We're writing about stuff all the time. In fact, we just had something on Portland today with a insane ballot measure that we for sure are going to have to do a video on, that particular thing. But with that being said, please keep staying informed, keep your powder dry, and tuning in. Till next time, guys.